Hi, I'm Kim Simmons. I'm CEO and founder of Law 365. Today, I wanted to bring a salient issue that you find in contracts, which are termination rights. This is particularly important with COVID-19 as a lot of customers are looking to see whether they have rights in the contract to terminate. There are two primary areas that you really need to focus on. These are termination for convenience rights and termination for cause rights. What do they mean? Let's break it down. Termination for cause is that someone in the contract has done something wrong, enough to allow the other party in the contract to terminate. What could these be? There's several different ways. It could be a material breach of the contract that hasn't been fixed within a certain period of time. It could be something that is a persistent breach, so not a material breach, but persistent smaller breaches that can occur. It could be insolvency. It could be also breaches that can't be fixed and the other party can prove that. So these are just some examples. There's often a laundry list of them that you'll find in your contracts. These are the sort of prevalent ones. So you've really got to watch out what that means. Now, just to take this a little step further, because I've got 45 seconds, one of the things you have to watch out for when we say material breaches, what does that mean? So you can do two things there. You can identify certain obligations within the contract, in other places of the contract, which both of you agree these are material things to do. And if you fail to do them, then obviously that triggers a material breach. Or you can leave it wide open and try to figure that out at the time. It just depends on your appetite to sort of go into the depth of that at the moment of negotiating. The second thing I wanted to talk about is termination for convenience right. The termination for convenience sounds exactly what it does. It is a convenience right. It's what I want to do. I have no reason or rhyme to do it. It is just something I want to do. It's dangerous if you have a managed services contract because you want to keep the support arrangement for a long time. You don't want your customer to leave and exit within a certain period of time, say 30 days notice, and all that lovely cash flow forecast that you put in for that client has disappeared overnight. So be really careful with these clauses. They are called termination for convenience. You will see it written in that way, and it will give the other party a certain period of time to notify the other party as to when they can pull out of a contract for whatever reason, no reason at all, okay? These are really prevalent more in professional services contracts because actually you have more of a build and buy type of situation. Whereas managed services is an ongoing support, you really don't want to have them in there. Okay, that is just over 2 minutes. I promised people that I would try to keep this short and sweet. We have written a COVID-19 free ebook, which talks about delivery delays, termination rights, force majeure, the whole works. This particular issue is discussed further in the link that I've sent below. Thank you very much for listening, and I hope to see you again soon. Thank you. Bye-bye.